How's it going, everybody? I'm back. I am not an attorney. This is not legal advice. If you want legal advice, go get yourself a competent attorney. I'm making this video with some case law that applies to the United States and to California. Hopefully you guys can also spread this information to people that do not know. If you know anybody that has, for example, a speeding ticket, DUI, whatever the case may be, doesn't even matter. If they're being charged with a crime when there's no victim, then spread the word. Spread the word. Especially with nowadays the state is going broke here in California. I've had a lot of people come to me saying that these certain cops were lying and just planted stuff or whatever the case may be. It's kind of crazy out here right now. It's almost like the Wild West, really. I mean, it's kind of sad, but that's really what's going on. People haven't been fighting for the rights, so now they're taking over. So anyway, I'm going to read this to you guys, and hopefully you guys enjoy it. For the answer, let us look once again to the U.S. courts for a determination of this very issue. In Hurtado v. California, 110 U.S. 516, the U.S. Supreme Court states very plainly, the state cannot diminish rights of the people. If you don't know your rights, you're screwed anyway, so who cares? And in Bennett v. Boggs, statutes that violate the plain and obvious principle of common right and common reason are null and void. Would we not say that these judicial decisions are straight to the point, that there is no lawful method for government to put restrictions or limitations on right belonging to the people? Other cases are even more straightforward. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis v. Wechsler. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona. The claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S. Miller v. U.S. is really good. That's one of the ones you can use if you want to be like me and say you have a right to travel. But that's me. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Shearer v. Cullen. That's another good one. They pretty much go hand in hand. We could go on quoting court decision after court decision. However, the Constitution itself answers our question. Can a government legally put restrictions on the rights of the American people at any time for any reason? The answer is found in Article 6 of the U.S. Constitution. This Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, not one word withstanding. In the same article it just says, who within our government that is bound by the supreme law? The senators and the representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Here's an interesting question. Is ignorance of these laws an excuse for such acts by officials? If we are to follow the letter of the law, as we are sworn to do, this places officials who involve themselves in such unlawful acts in an unfavorable legal situation. For it is a felony and federal crime to violate or deprive citizens of their constitutionally protected rights. Oh, also it's actually treason and sedition. Many people don't know that. Our system of law dictates that there are only two ways to legally remove a right belonging to the people. These are, and I'm not going to mention because there's many public officials watching these videos, so go study, suckers. Anyway, I also wanted to touch on the subject of what I do when I'm in the court, because I got a lot more private messages. But let me tell you what I do. What I used to do when I was in front of a judge and I would have to plead because I was at arraignment, the judge would always, if I wouldn't want to enter a plea, because I was asking questions, not like I was just staying quiet, but I would ask questions. Is there a contract? Is there a corpus delicti? Is there a victim? Who's the injured party? Is there evidence of an injured party? The only thing I see here in the file is citation. These are facts, not an evidence. I mean, I used to go at it with this judge or this commissioner in L.A. We would go about it like 40 minutes at a time at arraignment. Almost every time I would go in front of him. And if you don't understand by what I'm saying almost every time at arraignment, let me give you an example. Right now, I'm in Glendale Court. I got 7 cases against me. I've gone 4 times. Court is coming up, and I will still be at arraignment, even though I've been there 5 times. So yeah, they can't get past arraignment because I know what I'm doing, and that's exactly how it's supposed to be. You know, they need to prove up before anything. So my point is that I would always have a judge enter a not guilty plea for me because I was asking just too many questions. Oh, not guilty. I'm going to enter a plea of not guilty because you don't want to enter a plea. Objection. That's all I would say before. Objection, Your Honor. I object. That's it. Now I've learned how to box them in. Okay, now this is not legal advice. If you want legal advice, go get yourself an attorney. Now what I do is I would say, Your Honor, before you enter a plea, I have a friend of mine who wants to represent me. He's not an attorney, but I was wondering if that's okay with the court. I mean, I would act stupid and more scared, of course. That way they can go ahead and hammer you with the law and say, no. Had a judge tell me, you can't do that, sir. He's not a licensed attorney and he can't practice law without a license. But, Your Honor, is that practicing law if he were to represent me? Of course it is, sir. I think you need to get an attorney because I don't think you understand, you know, the severity of this case. That's what he told me, as a matter of fact. Stupid. Well, Your Honor, for the record, I'm confused. Well, what are you confused about? I already told you he needs a bar card or a license to practice law. He can't practice law without a license. No, Your Honor, I'm sorry. That's not what I'm confused about. What are you confused about? Well, I thought, Your Honor, I mean, for the record, I moved the court to state by what authority you, as a trier of facts, are practicing law practicing law with a license from the bench. Set him up completely. He didn't even see it coming. Sir, you see, I'm authorized under the Motor Vehicle Code, blah, 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 pursuant to blah, 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 blah. Well, Your Honor, for the record, wouldn't that still be considered biased? And if that's the case, I'm going to deem that part of the motor vehicle unconstitutional. See, nobody does that. This is why people, I believe these judges and cops are doing what they want to do. Nobody's deemed any part of anything unconstitutional and fought it to the Supreme Court or even taken it to federal court. This is why they're still doing what they're doing. Because nobody said, hey, that's illegal, you can't do that. No, what do? Okay, where do I pay? Oh, it says I can pay with the credit card here. Oh, thank you. Oh, wait, now I gotta pay a fee because I'm using my credit card? Oh, man. Well, it's okay. I'll pay by check. I mean, that's really what's going on. So, I boxed him in, and he said, well, sir, what do you want to plead? I said, well, for the record, sir, there's, I believe, 6 different ways I can plead in California. And you've only told me of 3. Of guilty, not guilty, or no contest, or no contender. Same thing. Okay? Guilty is obviously I want to pay you, because I don't know my rights, and I don't know how to even start to defend myself. And not guilty is I'm agreeing with what you're. Well, I'm not agreeing with what you're saying, but I'm agreeing that it applies to me. That's really what that means. Either way, you're agreeing. And no contender, no contest is saying, well, I agree, but in case somebody is gonna sue me because I got in an accident, they can't use my guilty plea in this criminal court, in civil court. So it's almost like, oh, you know, it's kind of like blackmail, really. But so. That's what I said. I said, hey, you've only told me 3 types. And there's more than that. I said, Your Honor, for the record, I believe this is fraud is being committed upon this court. And I said, what was it that I said to that? I said, the process, I said, is full of infirmaries. And I'm deeming it unconstitutional. As a matter of fact, I said something similar like that to the judge over there or the commissioner in Glendale. He was like, we'll talk about that in your hearing. We'll talk about, no, objection, Your Honor, this is my hearing. And the room was packed. He called me first for arraignment. Big mistake. He knows who I am now. And I got to go back to court. We'll see what happens. So, Anyways, hopefully this has been helpful. I know I've been ranting and raving for a little bit. I got off track there, but my point is just spread this out. Talk to people who have had tickets. Ask anybody, have you ever got a ticket? We'll check it out. Check the site out. Because if it's just one or two people doing it, I mean, even if we were to sue, for example, if I were to sue City of Glendale, for example, for say $2 million, in the end, they probably make that in what? About a week. Because you got to figure out how many DUIs they got, how many traffic lights. Traffic lights are $400 per person. If you want to fight it, I think they drop it to $200. So that's another hint. If you want to go ahead and pay, at least plead not guilty, and then they'll drop it, and then you can still pay less. And if you choose not to pay, then you know what? You deserve to pay the $400 or $500 that they're gonna charge you. So, just my opinion. All right, guys, have a good one.